Good afternoon, everybody. This is Jonathan Ruthie, our Executive Director for CS&I, and I want to welcome you all to our webinar series. Today's presentation is on guardianship, and we're really pleased to have Ann Butenhof back from the law firm of Butenhof and Baumster, and her partner, Judith Jones, who's going to be helping to provide all of you with information on guardianship. We're really excited to be able to continue to offer our educational series, and this is now, I think, the third in our series. We've got additional webinars planned for the next couple of months, and we'll be sending out information about that after today's webinar. Just before we get started, I want to point out a few things about the webinar. First, we ask that all participants in the webinar stay on mute or mute your microphones so that we don't have any interruption during the formal presentation. And I just want to point out a few features of the Zoom webinar application that will help us as we go along. We're intending to hold all questions until the end of the webinar, and if time allows, we will answer them all as they come in. If you do have a question, the best way to get that to us is to move your mouse over the bottom of your screen until you see an icon for Q&A. Click on that icon and a new window will open up that'll allow you to type in a question. When you submit that question, it'll come to us and we'll gather all the questions together. It's likely that if you have a question about something, somebody else does as well. So all questions are welcome. And so then we'll have those questions here and be able to pose those to our presenters today. If for some reason we're not able to answer everybody's questions in the time that we have allotted for the webinar, we'll be happy to respond to them in writing afterwards. And if you have an unanswered question, or if for some reason you're having trouble with the Q&A feature, you can email it to Heather Young, and that's H-Young, Y-O-U-N-G, @csni.org. We will send all participants a brief survey after the webinar, and we do ask that you provide us feedback so we can continue to improve the quality and content of our webinar series for your sake. So without further ado, I will introduce to you Ann Butenhof, who will kick off our presentation today.
Okay. And the video piece doesn't have to be on, or it does?
Right. No, it's because it's on share screen.
Okay, great. So, all right. Hello, everyone. This is Ann Butenhof, and as we mentioned, I'm here with Judith Jones, and Judith is actually going to be starting the webinar today, and here she is.
Hi, everyone. I'm very happy to be here, and actually also excited. I thought it was a video and audio, and we happen to have chocolate in front of us, so we're having some comfort up at our end. So let's start with a little bit about guardianship. And what Ann and I are going to do today is we're going to look at what happens at age 18. We're going to look at one hypothetical individual named Sam and considerations made about Sam and whether he needs a guardianship. Ann's then going to talk about alternatives to guardianship. Then we'll look at guardianship in more detail, and we'll walk through the facts about guardianship in different scenarios. And finally, Ann's going to end, and she's going to look at the importance of having future written guidance for your loved one, your child, for care in the future. So let me start off really by talking about age 18 and why this is so important. And can be just a birthday, but really age 18 in New Hampshire, an individual becomes an adult, and automatically that individual is presumed to have capacity to make decisions. And those decisions are about all life events. And if we now introduce our friend Sam, Sam just turned 18 and he's still in school. And let's look at what kind of inherent rights Sam would have at age 18. Those would be to make his own choices about where to live, where to travel, healthcare decisions, how to spend money, how to take care of his body. So all those things become the right of Sam when he turns 18. In some situations, there's a harder question to ask. Is Sam able to handle his personal medical decisions and his finances? Could Sam be vulnerable to others? So why don't we take a look at our hypothetical Sam? And in this situation, we've got Sam and he's living at home. He has disabilities. He could apply for SSI, supplemental security income. We know Sam spends his money quickly. We also know that Sam's a generous guy and he shares freely with his friends. He's just very generous. Now, because Sam turned 18, what's happened automatically is school officials can't speak to Sam's parents without his permission. Same thing with a medical provider. Sam's parents need Sam's permission to speak to the medical provider. Also, if somebody's applying for benefits, if Sam wanted benefits and a parent wanted to assist, they need Sam's permission. This can be a little bit of a shock and a little bit of a concern and just needs some attention and careful thought. In Sam's case, what we have is the example of he has decided to go for his driver's license. He wants to do it, and all folks around, doctors and family, agree that he shouldn't be driving. Now, there may be other scenarios in a hypothetical Sam that are similar. So what we're looking at are what are the issues that could come about at age 18. But this is a picture of our Sam, and we want to think about, well, what do we do? And how can Sam be helped?
So before considering, this is Ann Butenhof, before considering filing for guardianship, it's important to think of what other alternatives there might be. So if one of the issues is that Sam really shouldn't be handling his own income, like a supplemental security income check or a Social Security disability insurance check, then someone can apply to become the representative payee with the Social Security Administration, and that could address that specific issue. Sometimes it's a matter of simply adding a name to a bank account so that there's another signatory to the bank account, and then someone else is monitoring what's happening with the money. And the next thing we really want to talk about are advance directives. Now, we at our last seminar, we did talk about advance directives at length, but we were really focusing on your own estate planning, what everybody over the age of 18 should be thinking about. At this point, we're really talking about, well, what if your child turns 18? How can you step in to help that person? And maybe going to court isn't the best alternative. So with an advance directive, this is a way for Sam to make a decision about who's going to help him handle certain things. And in order to even consider this an alternative, Sam has to have the requisite mental capacity. And he needs to be able to identify people that he trusts that could assist him with various things, whether it's healthcare decisions or financial. Then if those are there, he may be able to consider this as an option. So as a reminder, powers of attorney, we have financial and healthcare. And one thing we want to talk about in this series is also that you could have a very limited power of attorney for something like education. You can have it very directed towards educational matters. We're going to talk about these concepts of a limited or general power of attorney, the fact that powers of attorney can be temporary or durable, meaning that they last even after someone loses mental capacity. And we're going to talk about the concepts of springing versus being effective immediately. So the purpose of any power of attorney document is that you're authorizing someone else to make decisions for you. So the person who is signing the document is known as the principal. So if the hypothetical Sam has the mental capacity to sign a power of attorney document and understand it, then he is the principal of that document. And the person that he is naming to help is the attorney in fact or the agent. One thing about powers of attorney is that they are revocable. And this concerns quite a lot of parents actually. They think that maybe their child has the ability to sign a document and understand a document like this, but then they recognize that that person could just get mad at them tomorrow and maybe revoke it. So that needs to be thought through carefully, but they are revocable. The authority of the attorney in fact or agent is completely controlled by what the document itself says, no more or no less. And if you're over the age of 18, which is what we talked about at the last webinar, you really should consider executing one of these if there is the mental capacity to do so. So I mentioned the concept of whether a document is limited or general. A general power of attorney is designed to encompass virtually any type of financial decision that might arise. So it's going to cover everything because you can't possibly imagine what every hypothetical situation might be. A limited power of attorney would grant authority to accomplish a specific task. The authority to speak to your therapist, to speak to your teachers, represent you at certain meetings. For myself, for instance, a limited power of attorney might even be to represent me at a closing for real estate. When I'm selling a house, but I'm going out of state, I may need someone to do that for me. And I wouldn't want to give that person the power to handle every aspect of my financial life. I would want to limit them to a specific task. And Judith, you should feel free to jump in anytime you think I want to add something else. I do want to talk about the concept of durability. When you're planning for your own estate planning, when somebody is doing this, they're doing it while they have mental capacity, thinking that maybe at some point in the future they will lose their capacity to make decisions. And in order for a power of attorney to be useful in that situation, it needs to have magical language that says it remains valid when someone loses capacity. And that's what the term durable means. If it doesn't have that language in it and the principal loses mental capacity, and this is often the situation with, say, a traumatic brain injury or developing dementia or some other progressive illness, then the power of attorney is no longer valid. So the next concept is the difference between a document that is springing and a document that goes into effect immediately. When we use the term springing, we're saying that within the document itself, it explains when it's going to go into effect because it's waiting for a specific event to happen. So, in a common scenario is you're waiting for there to be a lack of capacity. So we'll go over this specifically with healthcare powers of attorney, but financial powers of attorney can also include that sort of springing language. A power of attorney that goes into effect immediately means that the agent doesn't have to prove that the principal lacks mental capacity, whether it's to schools or financial institutions, before acting. So it's a personal decision that someone has to make as to whether their particular document will be springing or immediate. Do you want to say anything?
I think it's fair to say that more recently with financial powers of attorney, what appears to be more popular are not the springing powers of attorney, but what appear to be the more popular trend is to be a general durable power of attorney.
They're certainly more useful with basic estate planning. And I have had a few clients in the past that have insisted upon springing powers, and they've also generally been people that have had some form of mental illness that has a schizophrenic or type of component to it. But yes, it's helpful not to have the springing language, because otherwise you're constantly having to prove that this person lacks mental capacity when you're using it.
Folks, this is Jonathan Ruthier, and I just want to jump in real quick because I know we've had a few people join us after we started. You're on the CS&I webinar series, and today's topic is guardianship, although we're covering other forms of substituted decision making, such as powers of attorney right now. If you have a question, please feel free to use the Q&A feature of the webinar platform. Just all you have to do is move your mouse over the bottom of your screen. The toolbar will pop up, and you click on Q&A, and you can submit a question there. Thanks, and I'll give you back to Judith and Ann.
All right, so again, with a financial power of attorney document, you're authorizing someone to make financial decisions. This could be signing contracts and paying bills, filling out paperwork to obtain public benefits, anything, it's very, very broad. It covers anything, but it could include funding a trust that you might have, including a special needs trust that we'll be talking about later. So you want it designed very broadly to cover many situations. With a limited power of attorney, you're really, again, you're naming somebody to be involved in decision making, but you're limiting it to something specifically. Where we see this used a lot is for educational situations. So a child turns 18, they're presumed to have the ability to make all of their own educational decisions now, and yet maybe they really need you at an IEP meeting. They certainly might need your help negotiating with teachers and to obtain the different kinds of help that they might need, or filling out even financial aid applications. So you can generally serve as an advocate, but this has been a very useful tool. This slide is actually missing its language as well, but a durable power of attorney for health care and living will is a written document, and the person signing it, again, the principal, appoints an agent to make health care decisions at a time when he or she can't do so. What's interesting about this document is that it's not effective until a doctor declares that you lack mental capacity. So by definition, it is a springing power of attorney document. Many people think that when they have a child sign a durable power of attorney for healthcare, that they then are in a position to make decisions for their child. But if they have the mental capacity to sign this document, then they have the mental capacity to keep making their own decisions. So it's really not the best mechanism if you need to be involved in healthcare decision making. That's suggesting that the person doesn't have the mental capacity to make those decisions. Another important document is HIPAA. That's the Health Insurance Portability and Accountability Act, which is this act protects privacy in your medical records, and it prevents doctors and other providers from just giving that information out freely. So if the child, or you could put yourself in this situation. If you want to be able to share medical records with someone else today, without any need for mental incapacity, then you need to fill out one of these HIPAA release forms. They can be very key. This doesn't give someone the authority to make a decision. It gives somebody access to medical information and permission to speak to doctors. So when considering whether Sam, our hypothetical Sam, can take advantage of substituted decision-making by using powers of attorney, the first thing is, can Sam understand the nature of the document? Does Sam understand the role and appreciate the role of an agent as maybe taking over some of these decisions? Does Sam really understand that the power the agent might have with this, as well as the limitations on powers? So there's not a specific test given to figure out whether Sam has the capacity or not. When an attorney meets with an individual, we'll ask a whole variety of questions to make sure that this hypothetical Sam understands the document in front of them. Attorneys simply won't have somebody sign a document unless they feel very comfortable about the ability to understand it. And certainly they may not understand every word in the document. It's making sure they understand the concept and the different aspects of it, and making sure you know who you're appointing and why they are appointing a particular person. So we'll be moving on now to talking about guardianship. And when someone turns 18, as we mentioned, that person is adult and presumed to have mental capacity, and only a court can declare that an adult lacks capacity and needs a guardian. A doctor doesn't make that decision. A doctor is evidence in a guardianship action. A doctor can activate a healthcare power of attorney, but can't doesn't decide that the person lacks mental capacity.
So I think what this is useful today is laying out alternatives and then walking through guardianships, because what we find in our practice is the decision about what way to get support for decision making varies tremendously by individual, and it's a very personal decision. So I think what's great is we're walking through some of the alternatives, the benefits, the downsides, and now let's take a look at a guardianship. And let's say that Sam can't sign a power of attorney. He doesn't understand what the document says. Or you have a power of attorney, but Sam could still be vulnerable to influence of others, and it may be difficult. He enters into a contract, and it may be difficult to undo that without a guardianship. So let's just look at the role of a guardian and guardianship. So first, we're going to start really basic. What is a guardianship? And so guardianship is a statutory creature. There are statutes in place that give the court authority to create a relationship between two individuals. You have a guardian who's the decision maker, and you have initially a proposed ward. And the proposed ward, once the court has determined that individual lacks sufficient capacity to make decisions, then the guardian becomes the decision maker. So we're looking at the court, and the court has to make a finding, and the court has to rule that that individual lacks capacity. So we're going to take a little bit of time now to look at that whole definition of what is incapacity. So Anne had mentioned that this is not a medical decision, but it's a legal decision. And in New Hampshire, we have really what many advocates have said is a model statute. Incapacity is measured by functional limitations, meaning that there's proof that the ward would suffer substantial harm due to an inability to meet basic needs. And those basic needs are food, clothing, shelter, healthcare decisions, safety, or managed finances. So to get to incapacity, we have to have proof in New Hampshire, and this proof is established by showing there are some functional limitations that this person has, and also the impact of the functional limitations on that person's life. So a functional limitation it's a behavior or condition that impairs the ability to meet basic needs. Again, activities of daily living, food, shelter, healthcare. So an example of a functional limitation, let me make this a little more concrete, is let's say there is no understanding of math. Let's say it's me and I have no understanding of math. That might be true. But
We test this every day.
we do test it every day. But what we're looking at is really basic understanding for life skills. My math is bad, I'll confess, but I can read a bank statement and I can count change. So maybe my shortcomings in math are not going to affect my daily life. So talking more about functional limitations, we want to look at, well, how do you prove a functional limitation to the court? And what the court is really looking at are these very specific examples. They don't want to get a paper from a doctor that says, Sam has a diagnosis of autism. They want tangible examples of, in Sam's everyday life, is there an example of how his functional limitation impacted his health or safety? And we need those examples within 20 days of filing the petition and something within 6 months.
Everything within 6 months.
Everything within 6 months. So something that happened more than 6 months ago, it's irrelevant. So if we look back at Sam and we introduce Sam, what we said is, gee, Sam is very generous. He'll give away the shirt on his back. And so what you're looking at is, gee, is Sam the kind of guy where you're talking about, gee, he just shares snacks with his friends? Or has Sam given away his cell phone? He needs his bike as transportation. He's given that away. And when he gets birthday money, it's gone because his friends know how to get it from him.
So that means that's not isolated.
Right. So when you're looking at these functional limitations, you're looking at what is not a functional limitation. And as Anne says, this can't be just one isolated example. So what we have is, let's say Sam's excited, it's snowing, he wants to see a friend, he doesn't put on his coat, he rushes out to go see his friend. That's very different from someone who needs the help of a parent to tell them, gee, this is how you have to dress to go out. So you're really looking at the examples we're talking about for functional impairments. Is it just a one-time thing? Also, what wouldn't count is it just due to a lack of resources? So for example, I'm not meeting my basic housing need, and I'm not meeting it because I lost my job and I don't have the funds to pay rent. Well, that's different than I gave my money away and I really didn't understand I had to pay rent on a monthly basis.
Or someone who can't make change or understand, basic math, right?
So in this, we're looking at the court being careful. We want to hear about functional limitations. We want to hear evidence that occurred within the last 6 months and one incident within the last 20 days. We can't have it isolated. It can't just be a lack of resources. And the other caveat is, this act, is it the product of an informed decision? So when we look at informed decisions, we're saying, gee, the individual has considered the situation, they understood the choices, they made the choice voluntarily, and I understood the consequences of my choice. So we give another example. So let's say I'm not going to take a medication that's been prescribed. I don't want to take it. I'm not taking it because it gives side effects. but I'm willing to talk to the physician about maybe an alternative. How does that differ from, I've decided all medicine is poison and I'm not taking any medicine ever? So it's looking at, is that choice something that's, do I have the capability of thinking through and coming to a conclusion? The other caveat, which I love, is everyone has a right to make stupid decisions.
Bad decisions. Yeah, one of the things that is often used is, someone deciding just to eat Twinkies. Not a good decision, but they understand they have a lot of choice and they just make a decision that way. So sometimes you can't force people to eat well.
So let's go a little bit deeper into the guardianship process and what that looks like to start. And it is starting with filing a lawsuit. And in New Hampshire, it's called a petition. Now all of this is online, and there's a lot of great information on the New Hampshire Probate Court webpage. So if you just Google New Hampshire Probate Court guardianships, you're going to get a lot of good information and a lot of good question and answers and a peek at the forms that you'd have to fill out to do that. It's remembering that this process really is, by definition, it's adversarial, meaning that the proposed ward is going to get an attorney.
It's going to be appointed by the state, right?
Yep, the part of the petition automatically, if there's a guardianship, let's say against me, I'm automatically going to get an attorney. I may have to pay for the attorney, but if I have no funds, the state's going to pay for the attorney. And what's involved in the guardianship proceeding is putting on a case. And putting on the case it may involve medical records, it may involve family testimony, it may involve provider testimony. And as we go through this, we'll look at the different components of that. A question that sometimes comes up is, well, I want to seek guardianship. Do I need an attorney to do that? And I think that is a case-by-case decision. And as an attorney, I'm always looking at, would it benefit you? Maybe you don't need an attorney, but would it benefit you to have a one-time consult with an attorney to help you make that decision and maybe walk you through the process? So in New Hampshire, when we talk about guardianships, and we saying, as the slide says, it's not easy and it shouldn't be. And we say it shouldn't be because under a guardianship, a lot of rights are being taken away. You're having a decision maker. And so we want to put protections in the legal system to make sure we've given this proposed board the chance to show whether or not he or she needs a guardian. So part of the protections are, there's a legal presumption that any individual who's a proposed ward has capacity. We're going to go into court and we are going to presume that. And the person wanting guardianship then has to rebut that presumption. They have the burden of proof. They have to go in and show, gee, there's a need for the guardianship. And then we have standards of proof in the law. And for the guardianship, we have a very high standard proof.
And the highest standard that the legal profession has.
It's beyond a reasonable doubt. Other standards you might have heard of are by a preponderance of the evidence or more likely than not. And here we have beyond a reasonable doubt. So this system may at first be, could be upsetting to parents, really feeling challenging because maybe the parent knows the child the best, feels strongly they can take good care of the child, and it could feel a little insulting or affrontive to have to, gee, now I have to go into court and show what I've been the best at this job. So usually when we have clients who are going forward with this, it's just preparing them for that kind of proceeding.
I do think it can help to think of yourself in this situation. If somebody is claiming that you lack mental capacity and you're pretty sure that no, you have mental capacity, you'd want them to have to come forward with significant proof, because otherwise they're taking away your ability to decide where you're going to live and how you're using your money. So This is why we have such a high level of proof.
And we have to say that we have had cases, and I know I'm thinking of one case that Anne had particularly, where we had a client with capacity and had to put on a case to preserve that person's rights. So it's a system that can feel awkward, but there's a basis for it. The other piece I wanted to mention that can feel hard for parents is knowing that, gee, my child is going to have an attorney appointed to them. And it's good to clarify the role of that attorney. The role of the attorney is to follow the wishes of the client. And this was set in New Hampshire, finally settled by a case called Henderson. And it's clear under that case, if I'm the attorney representing a proposed ward, I can't recommend what I think is best for my client. I have to do what my client tells me to do. And I give an example. We represent proposed wards, we represent petitioners. I had a case representing a petitioner who clearly absolutely needed a guardian.
Not a petitioner, then a proposed
I'm
ward.
sorry, a proposed ward. And this proposed ward absolutely needed a guardian. And I knew that, but he absolutely didn't want a guardian. So my job at that point was to work with him to put on a case to do what my client wishes. So more on the types of guardianships. There are different types of guardianships and different scopes of guardianships. So in the petition itself, when you fill out the form, you've got to make a decision. Is this guardianship going to be over the person only? And that relates to healthcare, education, travel, where to live, whether I vote, whether I marry. By contrast, there's guardianship over the estate, and the estate really looks at finances. You can ask for guardianship over both, or you can ask for guardianship over just one of those areas. So the next slides, what we're looking at is back to Sam, and we're wondering, gee, I wonder if he's going to agree to the appointment of a guardian. He has a court-appointed attorney who's going to advise him. Will he agree or maybe not object? And again, this slide talks about, well, what's the role of that legal counsel? How Sam asserts his rights is really going to drive how the hearing functions. So often in guardianships, what we find is the proposed ward meets with the attorney. The proposed ward has no objection. Actually, I've had a proposed ward who really welcomed the guardian.
I've had many like that. Many 18-year-old kids recognize that they really need the continued help of a parent.
And in that kind of case, what might happen in court is we're going into court, the judge may start with counsel for the proposed ward and go off the bat asking if there's an objection. And if there's not an objection, then the judge may move to petitioners. The petitioners still have to put on a case, but there are some ways that judges can be thoughtful, because let's look at this. We have to put on a case. We have to show that this person lacks capacity. How does the proposed ward standing there feel about that? We have some judges on the bench who are very, very thoughtful about that. I've had judges ask the petitioners just to affirm the truth of the facts that are contained in the petition. There are ways for the counsel for the proposed ward to let them know, gee, you're going to hear a lot of things, but this is just to get the job done. It's not all of you. The other extreme with hearings you could get, where is if you have a proposed ward who objects to the guardianship. And in that case, you're going to have evidence, and you're going to have to bring in, you're going to have testimony, you're going to have to put on a case. And the hearings we've had hearings that last hours and are continued for the next day.
This slide is also missing its language, so sorry about that. But
yeah, it's a look at thinking about, if you're doing a petition for guardianship, who should serve as the guardian? And is it the parent? Is it a sibling? Is it a close family member? And looking at this, it's looking at, let's say it's me and I'm a parent. I'm going to ask myself, if I serve as guardian, would that interfere with my relationship with my child? Maybe I'd be relieved to have a third party or an agency or an independent guardian make those decisions.
And it can really depend upon the type of disability and the nature of relationship. But
So that's another issue to be thought through and to be considered. If we look at how much power does the guardian have, the statute says, gee, this guardianship has to be the least restrictive intervention, meaning that it has to be as limited in scope as possible. We want the ward to have as much freedom as possible. So when you look at the petition, there are check boxes. How many rights in the check boxes do you want control of? And what we're recommending is looking at those check boxes very carefully and thinking through what can the proposed ward do or not do. It's ultimately the judge's decision in how broad or narrow the scope of the guardianship is.
all right, so I know that we have a number of questions that have been made, so I am going to whip through the rest of these slides. I understand that these webinars will be posted and people can look at them again. So what we want you to know as a family member of SAM is that you know SAM best. You know, you need to provide instructions for future guardians, care providers, and trustees, because unfortunately none of us are immortal. We strongly believe that Sam should be included as an active participant and his wishes should be taken into consideration to the extent possible. And it's important to write everything down. You know, how is somebody going to know all this information if it's not written down? So family information and history. Let's understand the relationships of the people in Sam's life. What about prior family medical history? How that might impact Sam in the future. And for Sam, you know, we need a history of diagnoses, hospitalizations, medications. Who are Sam's doctors before and now, important professionals in their life, and we're looking again at past and present. Another important thing are just what are Sam's habits and hobbies and routines? You know Sam better than anyone else. You're in fact the only person who will know stress relieving techniques, who the support system is. Are there certain buzzwords or phrases that set Sam off? What are things, what behavior might be bad for Sam? Then you might have a situation where there actually is employment history, history of day programs. What is the preferred living situation that the family would like to see Sam have? And are there any educational limitations and goals? It's also important to know the government benefits information to maximize medical and financial assistance. I apologize that this is not on the slide. And what advanced planning did the other family members do? Is there does the parent have wills, special needs trusts in place? Is there life insurance? What type of support might Sam be facing when parents have passed away? So I did want to point out that we are a member of this organization called the Special Needs Alliance. It's a nationwide listing of attorneys, and you can go on their website and sign up for fabulous articles and actually look at a whole catalog of prior articles. And our office also has a newsletter if you wanted to sign up for that on our website. So
Well, thank you both for the presentation so far, and it's really been there's a lot of things to consider, right? And there are different documents, different methods for helping somebody navigate through the different types of, substitute judgment, and a lot to think through. And just real quickly for folks, we will be sending out the updated slide deck. So we apologize that sometimes PowerPoint has a mind of its own and it leaves a few things out. But we have the complete slide deck, and we will send that out to everybody who registered for today's webinar. And folks have submitted a number of questions, really thoughtful questions. So I'm going to start with a couple of questions that pertain to guardianship, and then there are also a couple of questions from the earlier portion of the presentation on powers of attorney. So the first question here is, it really relates to the rights that the ward has, and in particular the process for somebody who has a court-appointed guardian to be able to have the court change that decision, or have the person become able to resume their own agency.
Well, so you're saying there's a guardianship in place already, and you either want to change guardians, terminate guardians, or the whole guardianship, or limit what decisions the guardian can make.
And I think for this particular listener today, the question is more around what is the burden of proof that the ward has to provide in order to say to a judge, I don't need a guardian anymore.
Right. Good question.
My recollection is I may have to check this and then get a correction out by email, but my recollection is still that there has to be proof that a guardianship is still necessary. That's my recollection, that the burden doesn't go on the ward. But I think it's worth double checking, because it's a recollection in the back of my mind. But what we know is there's an annual report of the guardian over the person, and that the ward gets a notice informing them they have the right to try to terminate the guardianship. So that's something the court sends out, at least it sends out once a year, so that the ward has that notice. And also the guardian really would have a duty, if they believe that the guardianship is not necessary, to institute something to terminate the guardianship.
And this is another thing that we'll double check, but I do believe that if a ward does not think a guardianship is necessary and wants to bring a petition, they can ask the court to assign them an attorney again, because if they're indigent, so that's an important thing to think about.
Terrific. And kind of along the same lines, we have a participant who's asked, if somebody is appointed a guardian and there's maybe some suspicion that the evidence that was presented around their mental capacity is not fully accurate, or is somehow elaborated on in a way that's that doesn't really seem accurate to or true in that person's circumstances, is there a process for the guardianship to be removed or ended?
So if it happened at a hearing, I guess you'd say that you really want to get all your best information in at the hearing. So there's a chance to cross-examine. There's, Hail Mary could be during the hearing saying, we need a continuance, that there's additional information. We didn't expect this witness, and we want a continuance to get more information in.
So the bottom line is the process is the hearing itself, initially. And if you then come up with newly discovered evidence that everything was a fraud, then I think you file the newly discovered evidence. But the whole point of a hearing, and the burden being on the petitioner, is that the proposed ward with an attorney should put forth their best possible case, and say that if they have proof that this is completely inflated, out of proportion, and nothing is accurate, that's the time to do it. You want to show that those witnesses that are testifying aren't reliable, just like any other court case, really.
Right. So it's really incumbent upon the person who is being proposed as a ward and their attorney to be able to, make sure that the judge is looking at things through an accurate lens and that there's some veracity to the documentation.
And Judith is right. I mean, if you need more time because things came up that you weren't expecting, you have the right to ask the judge for more time. And, if the judge doesn't give you more time, you have the right to ask the judge to reconsider that decision. So there's a whole legal process that gives you the right to put on your case.
Terrific. And so we have one participant who's wondering about what's the difference between a guardianship and a conservatorship.
That's a great question. So
It depends on the state, by the way.
yeah,
We'll talk about New Hampshire.
talk about New Hampshire. It gets so confusing. So in New Hampshire, conservatorship is voluntary. And let's say it's me, I decide I'm not handling my funds well, I can petition the court and ask for a conservator. The benefit is the person acting as my conservator is subject to court oversight, but I can terminate that conservatorship. When you look at other states, it seems like the word conservator and guardian are used interchangeably. So it gets very, very confusing, but at least in New Hampshire, we know that guardianship is really what we're talking about, something that's not voluntary. Conservatorship is voluntary.
So for instance, in Massachusetts, guardianship is over the person and conservatorship is over the estate, but they're both what we would call guardianship. So New Hampshire is really unusual to have this conservatorship language for, a voluntary process to let someone else take over.
Great. And sort of along those lines, and thank you for mentioning, sort of the out-of-state regulations. If let's say I'm a parent and I live in Massachusetts and my child lives in New Hampshire and I want to file for guardianship, do I need to file in the state that I reside in or where my child lives? Or
Where the child lives.
it's always where the child lives,
Yeah.
okay, or the proposed ward. I know that folks have some questions around public guardians and whether or not there's either a separate process for petitioning the court for that type of guardianship. And it may be a situation where a person's treatment team or support professionals are wondering what would be the best case scenario in terms of who would be appropriate to serve as a guardian.
Yeah, there are private guardians and what we call public guardians. So in New Hampshire, there are two agencies that offer public guardianships. One is the Office of Public Guardian, and the other is Tri-County CAP. So they're nonprofits, and they serve as organizations and have a team of staff that can serve as guardian. And then in New Hampshire, there are also a handful of private individuals who've been approved by the court to serve as guardians. So the court has its short list of individuals it's vetted who can jump in and serve as a private guardian. So sometimes it absolutely makes sense for a family member not to serve as guardian. And again, that's something that's case by case and dependent on the circumstances.
But the procedure is the same. It's just that, in your paperwork, you're asking for the Office of Public Guardian to be appointed. But generally, the Office of Public Guardian should be approached in advance so that, they're given some information about this person. And they agree to be named on the document. And oftentimes courts, there's no suggestion about who would be guardian. And the courts will bring in the Office of Public Guardian or Tri-County CAP Guardianship Services.
Right.
But the procedure is the same. It's just how do you notify and find out who to ask and how to get appointed.
Right. And both of those organizations' websites have information on their intake process and what it, so frequently asked questions. So that'd be a good reference to do some further digging. There are a couple of questions around powers of attorney. And the first is it sound to have DNR or do not resuscitate language contained within a living will or power of attorney document?
Well, do not resuscitate is actually, whatever you put in the document, it's not the same as a doctor issuing an order. So only a doctor can issue a do not resuscitate order. And until that is in your medical chart, emergency personnel will provide, resuscitation. What the power of attorney document should do is give the principal, the person signing the document, the ability to decide whether the agent will have the authority to agree to a do not resuscitate order in the future. So a doctor can't just issue a do not resuscitate order. A doctor needs someone to agree to it. And if I lack mental capacity, does my agent have the authority to agree to it? So that's another very personal decision as to whether you're going to give someone that authority. But personally, I want my agent to have that authority because I don't know what possibly could be happening to me in my medical future. And it may look very, very dim. I could be a vegetable. And I don't, I want my agent to be able to decide maybe she needs a do not resuscitate order now.
One place to get good information about healthcare powers of attorney is the website, New Hampshire Foundation for Healthy Communities. And they have a wonderful book that walks through the role of the agent and advocacy and a checklist for making decisions.
And these are available at virtually every hospital and nursing home in the state.
Is there any sort of a registry, so when somebody files a living will or a DPOA over healthcare, that emergency room staff can access, or is that something that sort of is left to each person or guardian in that case to file with local hospitals?
There isn't one national registry. There is an organization, I think it's DocuBank, that will that you can pay to have your documents, available like nationally. Generally speaking, we recommend that just because you sign the document, you're not done with your job. You need to make sure that everyone you've named has a copy of it. You need to make sure your primary care and any specialists have a copy of it, and hospitals closest to you. And if you travel, you should take it with you. But there's not one national registry. But if somebody's really interested in that, they could look into something called DocuBank.
And we've heard, we've had clients say, like, if they know what hospital they go to in an emergency, that they are sending the documents to that hospital.
Great. And there's one more question from our audience, and this really relates to powers of attorney with respect to educational proceedings. The question is, would a power of attorney allow me to petition during IEP meetings that my child remains in school until the age of 21?
Well, you designed the power of attorney document to specifically address that. So in other words, if the child is signing an educational power of attorney, it's going to include the ability to represent Sam, at an IEP meeting. And what does that include? That can include exactly what this person is asking. So you want to make sure that the document allows for that. Do you have anything to add?
Yeah, the document, you want the document broad enough to include the possibilities that you're concerned about.
Great. So we're nearing the end of our webinar time. I just want to do a couple of things. One is thank everybody who has registered and signed in and participated and submitted questions today. I see I think we've gotten to all of the questions, thankfully, so that was really well timed. And I just want to kind of remind folks that today's presentation is not to be used or considered as legal advice. Today's information is really for educational purposes only, and your own circumstances really require you to consult with professionals So you have an opportunity to really, spell things out in terms of what your concerns are. So certainly feel free to reach out to Butenhof and Baumster or, another estate planning or trust attorney that's close to you to seek advice. The other thing I wanted to mention is that, again, we will be sending out the updated slide deck to everybody who registered. And if you're participating by sharing a screen with somebody else and you were not registered, if you would like a copy of the slide deck, you can just send an email to Heather Young at CSNI, and the email address is hyoung, Y-O-U-N-G, at csni.org. And lastly, I just want to thank you, Ann and Judith, again for coming and sharing your time, your talent, your information with us, and for being able to provide such helpful content to our audience.
We're really happy to do it.
Great. So thanks, everybody, and we hope that you'll tune in to our next webinar in our series, which is going to be in November. And I just don't remember the date, but if you,
29th.
I'm sorry, the 29th of November, that will be on, it'll be information on neuropsychological testing, kind of an overview of when that is appropriate and what some of the results can help to tell you. We'll also be working with Ann and her partners on providing some additional information in future webinars related to special needs trusts. And so stay tuned on our website for more information on that. Again, this is Jonathan Ruth here from CSNI, and we thank you for listening. Hope you all have a great day.